So we'll go to questionings now. I guess I'll begin with Mr. Harbeck. Would you agree that when SIPA was passed in 1970, the creation of the SIPC fund, capitalized by industry assessments, was the feature given the most attention in the floor discussion in the House and the Senate?
I'm not sure I understand.
In other words, the establishment of this fund, the focus was in large part setting up a fund because it provided liquidations of broker-dealer firms with another source of relief coming from the assessment.
That was absolutely one of the major components of the bill, yes, sir.
Right, and so it's beyond, by doing that, you're going beyond conventional bankruptcy to try to do what? To mitigate losses, correct?
That's correct.
Right. And so in providing for the supplemental relief to customers or failed broker-dealers, is it correct to say that the overarching congressional purpose was to restore and maintain the confidence of investors, particularly non-professional investors, in their continued participation in our capital markets for the benefit of the economy?
That is also correct.
Right. So, well, a couple points taken from that. Mr. Stein, what was the number you gave as far as where the distribution is at this point, as far as between regular, just retail investors versus institutional investors?
Well, that over 80%.
I'd love to address that, if I may.
Over 80% of the funds, in terms of dollar amount, will be going to institutional investors based upon the recovery numbers that the trustee and SIPC have provided.
And is it true, I mean, overall, have the majority of people who have been taken advantage of in the Madoff situation, have the majority of them received payments, or have the majority have not received payments?
The majority have, well, first of all, talking about direct investors, if we added indirect investors, that number of those who have received relief is fractional. But the majority of investors have not received any SIPC protection whatsoever, and a significant numbers of those who have received protection have had those protections, those amounts reduced significantly because of the net investment method adopted by the trustee.
And I should probably take this moment just to be clear here that we're talking about two, I don't want to call pots of money here, but two avenues of money of relief, right? One is advances. Correct me if I'm wrong if any of this, but the advances, which is basically comes from the industry-generated fees, right? And the other is the recaptured or recovered money when the trustee goes out and collects the money from the bad actors in this. Is that correct? Right. So there's two pots of money here. In the legislation that were before us, essentially we're talking about making sure that we're really not making any changes with regard to the recovered money. Is that? I'll go to Mr. Stein for that.
Well, the trustee is given a significant range of opportunity to apply what methodology he feels is most appropriate regarding the recoveries of customer property. But regarding SIPC advances themselves, this legislation is making clear that the trustee does not have the right to change the intent of SIPA law to suit the purposes of the SIPA fund or any other rationalization he can come up with to do so. Right.
Mr. Hammerman, I do appreciate sincerely your opening comment with regard to your concern for the victims and also for your statements and your association to try to work with this on this legislation. I do appreciate that. One comment that you did make, though, well, you did say, and I agree with this point, you said fraud is a fact of life, and you said something that has been with us always. Words to that effect, you said. Ponzi schemes, I guess, have been with us always. You didn't say that, but I guess that means that you would agree with that in one way, shape, or form or another, right? So if that's the case, then back in 1970, when they created this fund and they created this law and they created the fund and they created the whole, and the focus was on the SIPC fund, they must have known at that point in time that Ponzi schemes existed. But I didn't see anything in the original law, and I certainly didn't see any in the Senate discussions on this, where they created a Ponzi exemption. When did that come about?
Mr. Chairman, there is no Ponzi exemption as you explain. The way I understand the way it would work is if you as a customer gave, let's say, $100,000 to a brokerage firm with the expectation that the brokerage firm would buy securities for you in the account, and then that brokerage firm turns out to be a Ponzi scheme, for example, then you would be covered for that $100,000 of cash that you gave for the purpose of buying securities. full stop. What would not be covered is, let's say you gave that $100,000 and the monthly.
But that was, I know where you're going to go with this, but that was not said in the original law. Isn't that just a creation of later court cases?
That's not my understanding, but I'm not
Okay.
going to
Well,
profess to
I
be an
just-
expert in SIPC and the court cases.
Okay. And I'm going to be mindful of the time because we're coming up on votes. So I have a whole series of other questions, but I will return, probably second round, to the gentlelady from New York.
Thank you, Mr. Chairman, and I thank all the panelists. And I think the basic question is, what does SIPC insure? And going forward, what should it insure in the future? And how do we make that clear to investors? Because we heard from victims that in the case of Stanford, they weren't insured in anything. Is that correct, Ms. Kogut? SIPC did not insure or give any paybacks at all to the Stanford victims,
None
right?
whatsoever.
None whatsoever.
We actually haven't even been able to file claims because there is no liquidation, so we've had no right of a judicial review of if our claims are valid or not.
So this is a tremendous problem going forward. And in terms of Madoff, were payments done in Madoff or not from SIPC?
Yeah, approximately half the Madoff direct customers receive SIPC compensation.
What, 500,000 for securities, or what compensation did they get?
Up to 500,000. The average payment is a little less than that, but for those who are fortunate enough, and I say that with very carefully, when they were fortunate enough not to have needed to pull funds out of their plan to live on, they were able to receive SIPC compensation. And that gets to the fundamental problem and the public policy debacle that SIPC and the trustee are representing here. Witness as Exhibit A what Mr. Friedman has experienced. Here's a man who has put his whole life savings into a retirement plan. He retires with the intention of being able to live off that savings. And because he has withdrawn money to live off those savings, precisely as Congress would have wanted him to do, precisely as he needed to do, he is being tortured because those funds are being denied him. Any penny he has taken out in his retirement has been deducted from the amount of money that he has put in. So basically, anybody who is utilizing a retirement experience, been withdrawing funds for the cost of living over any period of time, have probably exceeded even the amount of money that they've contributed over their lifetime to their savings. We are actually reducing protections for those people precisely for whom we should be going out of our way to improve protections. And that is
And also
unfortunate
they're saying that if it's a Ponzi scheme, you're not covered. Well, obviously, they didn't know it was a Ponzi scheme. The government didn't know it's a Ponzi scheme.
Exactly.
And so I think a crucial issue, and I guess I want to ask Mr. Hammerman, what does SIPC cover now? And if you could get it back to us in writing, and what do you think it should cover in the future? And obviously, the situation of Stanford, of where no determination in a outrageous Ponzi scheme. I'd like to know from Mrs. Kogut in writing, where you say the SEC knew about this Ponzi scheme for 12 years. If anyone knew about it and didn't report it or stop it, that's a criminal offense. So that's a whole nother subject. We're looking at the SIPC monies now. So who do you think, what does it cover now, and what should it cover? And if you could answer some of the salient issues that the victims raised to you today.
Well, Ranking Member Maloney, as I tried to explain in answering the chairman's question, I believe today SIPC would cover an investor who put in, let's say, $100,000 with a brokerage firm with the expectation that the brokerage firm was going to purchase securities. And if that brokerage firm turned out to be a Ponzi scheme, that amount of money would be covered and advanced by SIPC. When you ask about what it should cover going forward, I think that raises an entirely appropriate...
Mr. Hammerman, that's not what she testified to. That's not with the Stanford people. They bought securities. They bought CDs that apparently the SEC and other people knew about, and then they're told that
The CDs.
that's not applicable.
Ranking Member Maloney, I do not profess to be an expert or extremely familiar with every underlying fact with Stanford. From my limited understanding, the investors invested in CDs issued by an Antiguan bank. Now, they may have, that is my understanding of what happened.
Well, at the very
And
least, then
foreign-
going forward, it should be very
No,
clear,
no, going
any
forward-
CD from a foreign bank, that nothing from a foreign bank is covered.
So-
Because they can't even get it resolved in the foreign bank. They won't even acknowledge that there was a problem. So the main thing is investors have to know what they're getting, and they were totally misled. They thought it was insured, that they would have this protection, and going forward, we made a mistake. It's in a foreign bank. You're not covered. So, I mean, I think we've got to be clear, at the very least going forward, that people know what their situation is.
I agree. I'm sorry, Mr. Chairman. I was just going to say, I agree on a going forward basis. We need to be clear, and there's a public policy issue about insuring against all sorts of financial frauds. The FBI estimates $40 billion of financial fraud a year. They also estimate $1 to $3 billion in micro-cap securities fraud.
Okay, thank you.
And the question is, what are we going to be?
Thank you. And I know but I want to get to the gentleman from Virginia.
Thank you, Mr. Chairman. I want to, first of all, thank the chairman for holding this hearing. I want to thank each of you all for being here. This is sort of rare in Washington, it seems to me, where you have folks who are not necessarily represented by moneyed interests here testifying before your Congress, a Congress that you own, about how to improve a law that clearly has been implemented in a way that is less than perfect. So I want to, as a former prosecutor who's dealt with people who've been the victim of theft, outright theft, I thank you for joining us today. And I thank the chairman for spearheading an effort to try to improve this, the way this works. I guess I would like to begin with Mr. Harbeck, who sounds like you've been with SIPC for 38 years total. Mr. Stein, in his opening statement and in his written testimony, indicated, and the chairman alluded to this, indicated that as a fact that institutions and professional investors are receiving over 80% of the recoveries in the Madoff case. Over $9 billion has been recovered, and that's a striking. I think that's a striking fact, as stated. Mr. Harbeck, I'd like to know if you think that is, if A, is that, do you agree with that, and B, if that is true, do you think that that's consistent with what the intent of this law was as passed?
Let's connect the dots. Thank you for the opportunity to do so.
But please be
The answer, sir, is that if an institution, such as a pension fund, has a claim with Mr. Madoff, and the pension fund has 1,000 indirect victims of Mr. Madoff, by paying that institution, one gets the money to the indirects. That's precisely how the system works.
So
the pension fund had the contract with Mr. Madoff. If it had a $10 million pension fund with Mr. Madoff, they've already got 4.2 back.
Do you believe that has been applied fairly, and is that the way the law is intended to work?
Yes, sir.
Mr. Stein, do you have a response to that?
Well, I think the first response is that it doesn't take into consideration the fact that you've got 1,000+ victims who have been denied any SIPC protection whatsoever. So let's just start there. That whether or not funds are going to a pension fund is immaterial to the monies that SIPC should be advancing to those small middle-income investors who invested directly with a regulated, registered broker-dealer as Congress and the financial service industry intended. Getting to the issue of a pension fund, a very small percentage of the total dollars that have been distributed to the institutional investors are going to pension funds, which is not to say that pension funds shouldn't receive their distribution, but Mr. Harbeck uses an example of an entity that's receiving a benefit. And in using that particular example, he misleads the committee as to what constitutes the majority of the entities that are receiving the funds. And the fact of the matter is that the kinds of funds, the kinds of institutions who the trustee himself has alleged could have known and should have known about this fraud were the ones that are receiving most of these funds. And the fact of the matter is that over 1,000 innocent victims are being sued.
All right, let me, I hope I have time for one more question. Again, to Mr. Harbick. A second fact that is stated in Mr. Stein's testimony is the fact that in addition to saving SIPC over $1 billion by the trustee's own calculations, the trustee and his associated consultants have similarly been enriched by almost $1 billion, funds which could have gone instead of the devastated and desperately needed, those who desperately needed it. Is that true? Would you agree with that as a fact? And again, do you believe that's consistent with the intent of Congress? And is that fair?
The $1 billion in administrative expenses in the Madoff case went to compile the $9 billion fund that the trustee
so you
has
think
been
that's
able
fair?
to recover. I think that's an extraordinary return. Yes, sir.
Mr. Stein?
Well, that's kind of patently absurd on its face, because $7.2 billion, or approximately, was immediately recovered by the Department of Justice early on in the trustees' proceedings, long before the number had reached $100 million. Another 2.2 was negotiated with another estate. So the amount of money the trustee has actually utilized to effectively recover funds has been an enormous amount. If you look at the investment quality, or the return on investment for the trustee for the majority of that $1 billion in expenditures, relatively small amount of money has been recovered from the large institutional investors.
Thank you. My time has expired.
Thanks. Gentleman from Colorado.
And I, again, want to thank the chair and the ranking member for tackling what is a very difficult and unsatisfying problem, because no matter how you push the balloon, somebody gets hurt, because this is all a sham, and everybody has been robbed from the beginning to the end. Now, the way I look at it, there are 3 pots of money. We talked about 2. There really are 3 pots of money, and I'm sorry, ma'am, you're Ms. Corgett, how do you say it? Kogut, pardon me. I mean, there really are 3 pots of money. You've got the insurance fund, and how big are we going to make that insurance fund so that we can cover people who've been lost, and how many tiers down? Is it the direct investor, is it second indirect investor, third? Then you've got the recovery that goes on among the people who've been defrauded. So, Ms. Sheen, your husband gets in at the end of Stanford, okay? You're helping the guys that got in earlier into the fraud than your poor husband and you. You're in 18 months before they close it down, but there were people in 3 years, 4 years, 5 years. They're the ones getting interest payments off of your money. So that's the second. So then you're trying to figure out, how do we resolve so that everybody's treated equally? The early guys get paid, but the late guys don't get paid. They're hurt. And then there's the third pot of money, which Ms. Corgett, you reminded me of, is those people who got you into the deal. Okay, whether it was the lawyers or the accountants or the advisors or some other company, and then there's all those lawsuits about...
Actually, there are no lawsuits.
Well, they certainly are in the Madoff side.
Well, there should be.
I don't know
also.
about on the
There
Stanford
should be on
side,
the
but there
Stanford
certainly
side.
are on the Madoff
There's a litigation
side.
stay that has been in place since February 2009.
So here's the question, and I appreciate the ranking member and the chairman for tackling this. Do we try to even it out? Is equity, is everybody was robbed, so everybody's going to be treated equally, or do the first people get to make out better than the guys that put their money in at the end? That's a policy question. For me, I think the equality, everybody being treated equally, is appropriate. You then have the lawsuits against the advisors, and then you have the question is, how big should we have this insurance fund? And will the broker-dealers or the taxpayers add to that insurance fund? because the losses from Madoff and the losses from Stanford are so huge, they swamp the fund. It's just gone. It's bankrupt because we haven't made it that big because we hadn't seen those kinds of losses before. And in my previous life as a lawyer, I represented victims of Ponzi schemes. I represented trustees trying to collect money for the victims of Ponzi schemes. These are horrible situations because everybody, and I want to use a crass term, but I'm not going to since I'm on the mic, everybody is robbed. And I don't know that there's a good answer. Ms. Sheen, please.
Well, one of the things that confuses me is that we invested in Stanford Trust.
It's all phony.
But Stanford was a member of SIPC.
I absolutely, I agree. And
as an investor, when I purchased an IRA, government-approved account, or I should say my husband did, and all my statements come from Baton Rouge, Louisiana. There's no mention of Antigua.
I know, but it's snake oil. It's not real. That's the problem. And when you brought up that the SEC knew 12 years in advance, okay, that is horrible. And I don't know how we want to try to compensate you from that. That's terrible.
So since Stanford was a member of SIPC, what is SIPC covering?
There ought to be something from the insurance fund available to you. And I don't know why you're not getting some recovery,
Right.
But there were so many people making a claim against that fund, it's gone.
So they were accepting money from a brokerage firm that was being run illegally.
Correct.
Can I comment on that?
Sure.
Part of the provisions of SIPA, 78 EEA1, if the SEC or any self-regulatory organization is aware of facts which lead it to believe that any broker or dealer subject to its regulation is in or is approaching financial difficulty, it shall immediately notify SIPC. However, in 1997, the SEC had an item of interest in their very first exam.
No, so that is a troubling fact, and I'm not sure what the heck to do with that.
Well,
Because you don't have to have a claim against the United States, I'm not sure you could do it, but I feel like you have a
there
claim.
have been lawsuits against the SEC. The one that has moved forward the most is the one that has alleged the SEC's violation of SIPA for this particular rule because the broker-dealer had a negative 1,400% loss year after year. So they're a negative operating loss, and it grew every single year.
And I look,
Why
guys,
didn't SIPC do
your testimony is very compelling. My time has expired.
Gentleman's time has expired.
And I appreciate you all coming here and sharing with us.
And-
This is a tough deal, and I appreciate them tackling it. I'm not sure they've got the right answer.
Well, I appreciate that the gentleman's time has expired. Also appreciate the fact that the gentleman indicated that Ms. Sheen probably should receive something from the SIPC fund. Randy, Ms. Holfgren is...
Thank you, Chairman. I, too, thank you all for being here today. I know this is a very difficult thing. I'd like to focus my questions for you, Mr. Harbeck, if that's all right, just for me to help understand a little bit more of some challenges here. Focusing on the SIPC Modernization Task Force report, I know one of the recommendations is to eliminate the distinction between claims for cash and claims for securities during the resolution of a failed broker-dealer. First, wondered if you can explain why this distinction between cash and securities claims may have existed before, and second, why SIPC feels the distinction is no longer appropriate or necessary.
Well, first of all, that's not SIPC's position. It's the task force position, and the SIPC will be responding to the task force on or before its next February board meeting. But the original distinction tied the amount of cash directly to the amount of cash available for the FDIC and rose with that dollar number. But in point of fact, sometimes cash gets literally caught in the form of a check going to someone when they didn't really want to leave cash with the brokerage firm. It just happened to be caught as cash as the brokerage firm failed. The task force looked at that and said it might be appropriate to simply abolish the difference.
Wondered if you could explain how fictitious securities are categorized in this process. And as you talk about that, are claims for fictitious securities considered cash claims or security claims? I understand there's been some confusion over that in the courts, and wonder the SIPC's position on that.
There's a split in the circuits on this. The Sixth Circuit has taken the position that the only conceivable way to measure cash legitimately deposited for the purpose of purchasing a security, which does not ever exist, would be protected as a claim for cash. The Second Circuit has taken a different view and protected it as a claim for securities. But one important thing with respect to any claim for securities is that SIPC, under no circumstances and in no case was it ever intended to guarantee the underlying value of a security. SIPC was designed to get you your security back. If it went up, excellent. If it went down, that is the way the marketplace works. Under no circumstances, regardless of why a security moves up or down in value, does SIPC protect the underlying value. It simply returns the security to you.
I know another recommendation from the SIPC Modernization Task Force report was to increase, or is to increase, the maximum level of protection from $1.3 million and index it to inflation. If the distinction between cash and security claims is eliminated, effectively eliminating any cash maximum, and the level of protection is raised to $1.3 million, this means that all cash up to $1.3 million would be SIPC covered. That's over 5 times the level, I know, of FDIC coverage. Is that desirable, and how might that affect cash holdings in deposit accounts and brokerage accounts?
I think there may be unintended consequences to the task force's recommendation, and I am sure that the SIPC board will be actively debating that and has begun that debate already.
And that response will be in the next few months, is that?
It's my understanding that the board intends to reply to the task force on or before its February board meeting in 2014.
Okay. One last thing. Appreciating one of the fundamental principles guiding SIPC is to certainly to protect small investors. I wonder how raising the maximum coverage level would affect small brokers. Surely you'd think this would raise broker-dealer assessments.
The fact of the matter is that what we will do when we reach the target of $2.5 billion, which matches the federal line of credit that we have against the United States Treasury, I'm confident that the board will assess whether at that particular point in time, our current assets are $1.9 billion, whether a target of 2.5 is appropriate or whether it should be increased. I think we'll take a hard look at where we stand and where our obligations are and what our legal obligations are as to whether the assessments should be raised, lowered, or stay the same.
Okay. Well, thank you all. My time's almost expired. I yield back. Chairman, thank you so much.
Thank you. The gentleman yields back. Mr. Carnegie is recognized.
Thank you, Mr. Chairman. I'd like to thank you and the ranking member for having this hearing today, and in particular for your tenacity on behalf of your constituents. Knowing how important our constituents are, I have great sympathy and appreciation for the work that you're doing, and appreciate in particular the victims who've come today. For me, I think our role is at some level to establish what the facts are and to try to come up with the best public policy, not just for these 2 terrible cases, the Sanford case and the Madoff swindle, but also going forward for everything else. So I'm going to try to, I think, address most of my questions to Mr. Harbach and Mr. Hammerman. First, I want to have some more discussion about the treatment of institutional investors versus retail investors. Mr. Stein, I think, said that 80% of the institutional investors were protected, and obviously a lot of retail investors were not getting assistance. Mr. Harbach, you mentioned the situation with pension funds. Mr. Stein seemed to take some exception to that. What is that the full explanation, or what other institutional investors might we be talking about here?
The statute makes no distinction between a corporate investor, a large investor, or a small investor. The measurement is how much, and in the Madoff case, how much net did that investor put in? So,
So is it the case that the institutional corporate investors put in more money than the retail investors? Is that part of the explanation?
Whatever the net amount in was, it was for any individual, whether it's a corporation, a hedge fund, or anything else.
So it would be your view that, in fact, the SIPC is not treating institutional investors any differently than retail investors in terms of the methodology that you're using?
The methodology is the same for all.
So should we look at that methodology if the effect is to, and maybe this is my word, favor institutional investors over retail investors? Or is there something in the methodology that gives preference to institutional investors?
It gives no preference to institutional investors. It gives preference to, on a pro rata basis, to a larger contributor to the fund. One other thing,
which at some level is fair, right? I mean,
well, especially when you consider that the institutional investor, whether it's a hedge fund that has partners, whether it's a pension fund that has pension participants, if that institutional investor is an innocent institutional investor, it will get a proportional share. One thing that I take strenuous exception to is the fact that any institution that should have known about this or is alleged to have known about this has not shared, nor will it.
Okay. Quickly, Mr. Stein, you're jumping out of your chair to get a point in here. If you, please feel free. My time is running out, but go ahead.
Well, I get back to the words that Mr. Garrett stated initially when he was referring to the opening comments that President Nixon made. This legislation and the statute was intended, its very purpose, to protect the small investor. I don't know how many times that point has to be reiterated for it to sink in to SIPC's conceptual thinking, but that is the essential point. So it is understood that professional investors and institutions have the resources and the recourse to be able to protect themselves and their investors.
So fair enough. So should the methodology then slant towards the retail investor?
I think it is a legitimate question to pose going forward, but I think interpreting the law as it is written now, I think, first of all, it is from a public policy point of view, it's essential we protect the smaller investor and the middle-class investor as it was intended in the
So that makes a lot of sense to me, and there's something to be said for that, but this does the kind of the fundamental part of the bill going from a calculation of actual net investment to last statement method, does that do that?
Well, actually, the bill that Congressman Garrett has written gives the trustee the ability to determine what is in the best interest when it comes to the recovery of customer property, that second pool of money that Congressman Perlmutter was referring to. So those monies that are recovered, we're talking about everybody getting their $500,000, the pool of money that is recovered, the trustee now has the ability to look to the SIPA legislation and say, what is the most equitable way to distribute this money? Do we give most of it to the small investor? Do we give most of it to the large investor? How are we going to split it?
That seems to me to be a fundamental question. My time has run out. I'd like to have additional time at some point, but I appreciate everybody coming in. Again, thank you to the Chairman and Ranking Member for your tenacity on this issue.
Thank you. And we're going to stay for 5 more minutes and then go to vote, or 10 more minutes, to go a second round without objection. So, Mr. Hammerman, Mr. Harbach, you heard the testimony or the statements by Ms. Sheen and Mr. Friedman as to how Mr. Sheen invested and how Mr. Friedman invested. Can you tell the committee, and I guess all the American public who is watching them as just regular investors going forward, can you tell us what exactly did they do as regular investors that was wrong in their process of making their investments?
Chairman Garrett, these
Yes.
victims did nothing wrong, nor has anyone ever said that they did.
Okay. Mr. Hammerman, did you, as far as the clients or the institutions in your association. Would you say on their behalf that either one of them did something wrong as far as their selection? Mr. Friedman told how he went out, knew about it, actually went to the company and went through it, which is sort of amazing. That's due diligence on my part. Do you think they did anything wrong?
Absolutely not, Mr. Chairman. These are victims of terrible financial crimes.
So if America is watching right now, and they put themselves in the shoes of Ms. Sheen and Ms. Friedman, and that those two people did absolutely everything right, and they went in and they saw the SIPC logo there, Mr. Harbach, and they saw and thought that there was a guarantee that SIPC would protect them. And now America realizes there is no protection, as you were saying before, both of you were saying before, for fraud or these Ponzi schemes. What is the answer then for that for other Americans? Mr. Harriman, should there be a addendum to, Mr. Harbach, should there be an addendum on the SIPC logo that when they go into any of Mr. Harriman's, any of the firms in his association, should there be a bold statement saying that you are protected by SIPC? However, if there is fraud by this firm, or if there's a Ponzi scheme by this firm, you will not be protected. I'm willing to do that. Are you?
Chairman Garrett, SIPC has given $800 million
Answer the question, please.
I am.
Answer the question. Should there be a statement
to the victims of a Ponzi scheme?
But you're not to this one.
Yes, sir. $800 million.
Not to Ms. Sheen, you haven't. Not to Mr. Friedman, you haven't.
We have not started a liquidation proceeding for Stanford because the courts have upheld the position that it is inappropriate to start such a case.
Ms. Kogut?
That's under appeal right now. It's with the D.C. Circuit Court.
So in the Madoff situation then, are you willing to say that if they had invested in Madoff as opposed to in Mr. Sanford's case, you're saying in this case you're willing now to have specific advances being made so that they can be guaranteed that those payments will be made?
SIPC advanced $800 million to the victims of the Madoff Ponzi scheme.
In the case where they're in the similar situations where they have withdrawn more than they have invested in the fund?
If you wish to put an addendum saying SIPC does not permit the payment of fraudulent, fictional profits, we would be in agreement. Because
how about this situation then? So I put in $1,000 a few years ago into one of these Mr. Harriman's firms, or his clients, and I've been taking out, like Mr. Friedman says, I took out enough just to pay my taxes, I took out just to pay my medical bills and so on. So after so many years, I've taken out my $1,000. But my statement says I still have $1,000 or more, right? Under your understanding, how much would I get from advances?
If the entire scheme is a Ponzi scheme,
right,
then the answer is
zero, right?
The answer is zero, and the reason the answer is zero, sir,
so what you're advising
me, it would take money away from people who cannot get their own money.
The time is mine. So what you're advising me to do is what I have to do and what they should do in the future. Everyone watching this should do in the future is when you go to a broker-dealer and you make an investment, you should keep track every day that you take money out of that broker-dealer. Every day you take out money to make a tax payment. Every day you take money out to make a payment for your insurance or your health care. Keep track so that you say, as soon as I get to that limit, in my case, my hypothetical, I took out my $1,000 original investment, you're telling me at that point my coverage with SIPC ended. So you know what I would do as a prudent investor? I would close my account with that dealer and I would walk across the street to another dealer, and at that point, it resets. Is that true that it would reset when I walk across the street?
I think answer
that question, please. Would that reset?
I'm trying to answer it, sir.
Yes or no?
The answer to your question is that if you did that, you would be protected, but it's not necessary. And it's not necessary because
Tell me how else I would be protected for that $1,000.
The answer is in the history of SIPC.
No, tell me how I should be protected.
Well, you should be protected by the regulatory system. You should be protected by the auditors of the firm.
Okay, so you know, you've been there for 38 years. You know you're not protected that way. So how am I going to be protected?
I believe that one of the things that have come out of the financial crisis is heightened review by the PCAOB of auditors of
So we don't... So we don't need SIPC anymore because my protection is not from SIPC at that point. It's from the SEC and the other agencies. Is that what you're telling
Certainly
me?
that's the first line of defense against fraud, yes.
That is. But I thought SIPC was my second line, my final line. You're telling me that SIPC's not going to be there for me. So I think that's one of the takeaways from today, is that you're willing to change the SIPC logo to say that there is a caveat and that your members will now have a caveat or statement, and that should be indicated to them on a regular basis. I think that's significant that we're going to do that. And secondly, your takeaway is that to be a prudent investor, as Ms. Sheen and Mr. Sheen and Mr. Friedman should be going forward, is that you should roll your money every so often from one broker-dealer to another broker-dealer as soon as you come to that capstone, because my only reliance is on the regulators. We know how good regulators are, and we know, you've just stated, that SIPC will not be there to protect me. I think that's a significant takeaway from this hearing. Ms. Kogut?
That's assuming that the Ponzi scheme has gone on long enough for all of the investors to have withdrawn anything. In my case, we invested 9 months before the collapse of the Stanford Ponzi scheme. But I want to point out that SIPC's website right now says SIPC helps individuals whose money, stocks, and other securities are stolen by a broker-dealer or put at risk when a broker fails for other reasons. But Mr. Harbeck has said SIPC doesn't cover fraud. How do you steal a customer's funds without defrauding them? Isn't that burglary? I mean, there has to be some level of fraud to steal money.
Yeah. This issue is so frustrating on so many levels. Mr. Harbeck, you indicated you've been there for 37 years. Can you tell me prior to this collapse, what was the insurance rate that you charged the member firms during that period of time? Is it on annual?
It's varied dramatically over that 38-year period.
Okay, well, just prior to the crisis in
Just prior to the crisis, when we had $1.6 billion, we felt that was enough, and there was a token assessment of $150 per firm.
$150.
Stanford paid $1,750 for their protection for their.
So Goldman Sachs in New York, they were paying.
At the time, they were paying $150 a year. Once we turned the assessment spigot back on, they paid tens of millions of dollars.
You know, just coincidentally, I'm in the market right now to buy a used truck. It costs $1,500. So I called up the insurance agent last night and I said, how much does it cost me to insure this truck that I bought for $1,500? They said it's going to cost you $1,000 a year to insure that truck. If I have homeowner insurance, it's cost me about $1,000 on my house. If you go to a Sears and you buy a large TV or something like that, the sales lady at the counter when you leave, they try to sell you one of these insurance policies. They cost you $200 or $300. Goldman Sachs is paying $150 for basically for coverage. That doesn't seem irresponsible to you?
I'll refer to my written statement where I've gone through SIPC's financial condition, Chairman Garrett, and we are currently in a stronger position than we were in 2008.
Right, but you were not in a strong enough position in 2008 not to have to make these draconian, what appears to be draconian increases, sudden increases, which I can understand completely when I meet with Mr. Hammerman and some of your smaller members, and they're saying, hey, I budgeted or I planned, and this is my operating budget, for this much, and all of a sudden, wham, I'm going to be hit this much. I can understand that. If your members had known back in 1980 was this much, in 1990 was this much, in 2000 is this much, as a business owner, you could probably have planned for that and made for appropriate adjustments in your operation, and I can understand that completely. But to go from next to nothing, less than a cost to buy insurance on a TV at Sears, to go to what some of your members, Mr. Hammerman, are going to right now, you can tell us, is this significant to them, the changes? The increase that some of your members are going to have to...
It sounds like from Mr. Harbeck's testimony that it's multiples of millions of dollars. So.
Right. And I can understand that that is probably unconscionable to your members' situation, and that they just can't adapt to it. That's why, Mr. Harbeck, when you say you've been there for years and you've seen this and ramping up to this, and the preparation wasn't made, it goes back to my opening questions. What did they do wrong? Nothing. What did the regulators do wrong? A lot. What did SIPC do wrong? Apparently not a significant amount with regard to preparing the fund and be in preparation for cases like this. Ms. Sheen? Okay. The committee will stand in recess. Mr. Stein, do you?
Yeah, I just wanted to, Congressman Garrett, thank you very much. I think you've hit a lot of the key points. I think there are two things that I would just ask for consideration here. I think we're finally getting a chance to shine a light on the culture of SIPC. I think it has been largely opaque for probably the 38 years that Mr. Harbeck has been there. I think the transparency is essential. I think we're getting to see some of the warts. I think we need to dig deeper. I think we need to truly see whether SIPC is, in fact, even worthwhile. Is bad insurance better than no insurance at all? The second point, more of an overarching issue, is getting back to what the concept was in setting up basic issues of certainty for the banking industry and the financial services industry. And that means that when people see a bank deposit statement or a bank statement or an investment statement, there has to be a certain level of certainty in order for those markets to operate with the kind of confidence and trust that allows this economy to prosper. Once we start chipping away and nuancing at those very, very fundamental assumptions, we are threatening great damage to our financial and banking systems. If we applied the same characteristics that Mr. Harbeck and Mr. Hammerman have just been speaking to the banking industry, to bank statements, to bank depositors, imagine the horrific result that would take place. I have to encourage the committee to consider, again, in all these decisions, what the impacts are going to be the financial industry and the importance of creating certainty and confidence in the markets, particularly now after what we have gone through collectively in this country.
Thank you. Thank you. Without objection, it doesn't look like I get any objections. I'm going to put into the record statement of, for the record from the Financial Services Institute, the GARO report of 1992, and a statement from here? Yeah, not a statement, but an email of May 21, 2009 of Mr. Harbeck relative to the matters that, well, we somewhat touched upon during the course of this hearing. We are in votes, and the other members I know will be leaving town, so I want to take this opportunity to thank each and every one of the witnesses who have come here. Appreciate your concern for this issue, and very much appreciate the testimony. We look forward to any input that any of you have on suggestions as we move forward on this legislation. There may be additional questions by members of the committee, both here and who are not here, that we may submit to you. We'd ask that you would consider them and reply to the full committee with them. And with that, this meeting is adjourned.